And my top tip number 1 is about making premises COVID-19 secure. And the tip in this regard is to follow the government's guidance and be mindful of the terms of the lease. So quite a long time ago now, back on the 11th of May, the government published the first batch of COVID-19 secure guidelines. I've put on the slide there a link which will give you details of the government's webpage that gives you all the guidance and guidelines in relation to being COVID-19 secure. The guidance is both general in terms of key themes, and there's also specific guidance for particular workplace settings, and I've listed those there. There are 14 in total, but it's possible, if not probable, that that list will grow. Please note there's also separate guidance for educational and childcare settings, as well as for public transport operators. And I should also mention that there is separate and specific guidance for Wales, Scotland and Northern Ireland, which can be accessed through the link here. So as well as specific guidelines, the government have also published their general guidance, which includes 5 key steps that I've set out here. The government website goes into a lot more detail in relation to those 5 steps and what they mean from a practical perspective. I'm not going to cover them today. I'm going to focus more on the legal issues arising from them, but certainly worth visiting the government website. The government also has a separate webpage in connection with businesses reopening, and the link to that webpage is on the slide here. And also it's worth visiting the Health and Safety Executive's webpage. Again, contains lots of useful practical guidance about the type of steps needed within a workplace setting to be COVID-19 secure. So in terms of what that means from a landlord and tenant perspective, for tenants, it will in most cases require some form of alteration to their premises. Now, whilst most leases require tenants to comply with statutory requirements, the lease will still govern whether or not approval is needed from the landlord, and the terms of the lease remain in force and enforceable in that regard. That does raise an interesting question as to whether the government guidelines are statutory requirements. Taking the guidelines alone and viewing them in isolation, the vast majority of them are not. They are suggestions of what's needed to do. But occupiers, owners and employers need to keep in mind other statutory instruments. So for example, section 4 of the Health and Safety in the Workplace, etc. Act 1974 includes an obligation on owner, occupiers and those in control of premises to make them safe. And so the point being that if it was shown that a tenant didn't follow the government guidelines, it's quite arguable that the premises in question are unsafe. Where the alterations are being carried out that are non-structural and internal, most modern leases will include a proviso that the consent from the landlord, the approval from the landlord, should not be unreasonably withheld or delayed. And so that's certainly a point to keep in mind when alterations are needed. And the reality is that it's hoped in this sort of environment that a common sense approach will be applied. It's also worth keeping in mind the Landlord and Tenant Act 1927 and the tenant's ability in certain circumstances to carry out improvements to the premises. That can be used firstly in the context of the tenant obtaining compensation for improvements at the end of the term, but it could also be used in certain circumstances to give the tenant the right to carry out certain improvements to the premises that it would otherwise be unable to do under the terms of the lease. The difficulty, of course, is that the procedure under the Landlord and Tenants Act 1927, it takes time. An initial notice needs to be served in writing, and the landlord has 3 months within which to object to the proposed improvements. And of course, in the current environment, that's simply too long, except in relation to longer term alterations. But equally, from the landlord's perspective, it makes sense to engage with tenants and discuss any proposed alterations sensibly. The landlord needs to be also aware that it has its own obligations in relation to common parts and those areas of a building or a development which it controls. Again, the point I made about Section 4 of the Health and Safety in the Workplace, etc. Act 1974 is equally applicable in relation to those areas which the landlord controls. And so the landlord cannot simply assume that it's the tenant's responsibility to make premises COVID safe where there are common areas and common parts. So the next top tip, moving swiftly on, is associated to that. It's who pays for those works and who does them. Now, the tip here is essentially to carefully read the terms of the lease and have clarity in that regard. Ultimately, where the works are carried out within the tenant's demise, in the vast majority of cases, the tenant will be obliged to carry out those works and to foot the bill, subject to the point I made earlier about the possibility for compensation in certain circumstances under the Landlord and Tenant Act 1927, albeit that's something that tends to be exercised rarely in practice. In relation to those works carried out within the common parts, it's worth keeping in mind from the landlord's perspective that most modern leases do enable the landlord to recoup the costs of work carried out to common parts under the service charge provisions. But clearly, certainly in a commercial context, it's important to read the exact wording of the service charge. There may be a number of provisos, a test of reasonableness, and other points that mean that it's not simply going to be the case that any sum spent on carrying out alterations or doing works to the premises can be recovered under the service charge. But again, in the event that those works are carried out reasonably and to a reasonably cost, clearly they're there for the benefit of all concerned. I mentioned the 1974 Act, but it's also worth bearing in mind the landlord's covenant of quiet enjoyment. Of course, that's the covenant by which the landlord must ensure or not take any act which will prevent an interference with the tenant's possession and enjoyment of the property demise to it. And that might place an obligation on landlords to ensure that common parts are kept clean and COVID secure, especially if those common parts are a means of access and egress to and from the tenant's demised space. So top tip number 3, this is more a theme really. Well, one thing we've noticed in our practice over the last few months is that a number of corporate occupiers have been exploring the possibility of repurposing and using their space for alternative uses. And the tip here is get the most out of your premises. So this is particularly relevant in the context of a corporate occupier with a very large space whereby parts of it are unused for periods of time. A number of those corporate occupiers are seeing whether alternative uses can be applied. So for example, if you have a conferencing venue, they may speak to a nearby education institution about the education institution using the space during periods of time, which might help the education institution secure more face-to-face learning whilst adhering to social distancing rules. So if that is something that's of interest or applicable, it's important to check the alteration and alienation provisions. We covered when landlord's consent might be needed to alterations earlier. In connection with alienation provisions, of course, many modern leases will include clauses which restrict or limit the ability for tenants to assign or more applicable sublet or share occupation with third parties. And it's important to check the terms of the lease to see what conditions must be fulfilled to enable what's being proposed. It's also relevant in the context of the permitted user clause in the lease. Most leases include a clause which states that the tenant can only use the property for a particular use. Where that's defined, quite often you'll see the permitted use defined in the context of a use class, and an example clause is shown on the slide here. Now that's relevant because since the 1st of September, the new regulations have been introduced which introduced some fundamental changes to use classes, including the creation of a new broad use class E. And I've put on the slide here a table which shows how the use classes have changed. So you'll see that the use class E covers a number of uses, and the point being that changes within a use class will not usually require planning permission, and so that opens up the possibility of using premises for different uses, certainly within a planning context. It's very important to note that the lease user clause must still be adhered to, and planning permission might be needed for any building works needed relating to the change of use. In relation to the user clause in a lease, for long leases granted for a term of more than 40 years, and with 25 years having already elapsed, or at least 25 years having already elapsed, there is the possibility of applying to the tribunal to modify the covenant under section 84, subsection 12 of the Law of Property Act 1925. Again, it's a process that can be followed. The big detractor in the current environment is the time that it will take. It will take an application to the tribunal, which obviously will take a number of months to reach a final hearing, which in the current context might be simply too long. I've given a snapshot here of some changes in planning law. This isn't a specialist area that I cover, but it's certainly worth bearing in mind that the changes in use class is part of a whole body of changes in planning law. And if this is something that interests you or you'd like to hear more about, I'll be more than happy to put you in touch with one of our planning colleagues. So that moves me on to top tip number 4. And again, it's a theme really, and it's that of frustration and force majeure. So clearly the lockdown had seismic impact on all of us really, in terms of our everyday life, but also within the context of business activity. It meant that for a vast number of businesses, the lease for which they'd bargained for could no longer be enjoyed, and it gave rise to the question as to whether frustration can apply to bring a lease in question to an end. So frustration can apply in principle to leases and also to contracts for the sale of land, but it does so very rarely. There was, of course, the well-publicised case of Canary Wharf versus European Medicine Agencies last year in the context of Brexit. There, the court held that the EMA was not the EMA's argument that its lease had been frustrated by virtue of Brexit because it could no longer enjoy the premises for which it had entered into a lease in connection with Canary Wharf. And but the court said no. The court said that the obligations under the lease remained intact and could still be adhered to, not with the EMA's inability to take occupation of the space, but also that the EMA could potentially assign the lease or sublet it to a third party. The point being really that frustration applies really only when the intervening event renders the performance of the particular contract, in this case a lease, either impossible or only possible in a very different way to that initially envisaged. And the point with the pandemic is that while it's incredibly disruptive and far-reaching, it is likely to be temporary, even if when we say temporary, it might mean a year, it might mean 2 years, it might potentially be longer. And so it's very hard to see in the context of leases how the entirety of the lease has been frustrated with all its rights and obligations in its entirety or in a very, very different way. The argument perhaps might have more merit in the context of a lease for a short term. So, for example, if a lease was entered into to cover a particular event or a short period of time, and that the whole of that event or that period is entirely disrupted by the pandemic, you could see greater force in the argument there. But it is certainly something that at this point in time, it's going to rarely apply, but it's a principle that's gaining greater and greater focus as the length of the pandemic continues. Where frustration isn't available, there might be the possibility of looking towards a force majeure clause in the contract, or in this case in the particular lease. the point here is that under English law, the applicability of a force majeure clause is contractual. Some contracts expressly provide for the performance of a contract to be excused if impacted by certain events. The difficulty is that force majeure clauses are construed narrowly against the party seeking to rely upon them, and it's very important to look at the precise wording of a particular force majeure clause. So, for example, in the context of property, a force majeure clause might require there to be actual damage to the property itself, and there is some doubt as to whether the presence of the virus within a particular property would constitute damage to the property itself. It should also be noted that force majeure clauses in their purest form are found rarely in existing leases. You tend to find them more in the context of rent suspension clause, and they're often connected to the applicability of insured risks and the triggering of insurance. It's worth noting, however, that in relation to new leases and new contracts for sale of land, certainly we're seeing where they're being negotiated, tenants seeking to incorporate tenants break clauses that are akin to force majeure clauses in the event that the pandemic worsens or does not recede. And again, we're seeing buyers arguing for contracts for sale of land being made conditional upon the pandemic receding. Now, the point about whether the force majeure clause will apply in a particular context takes us on to my top tip number 5, which is to keep an eye on the FCA's test case in relation to business interruption insurance. Of course, during the pandemic, one of the first steps that a number of businesses did was look to their insurance policy to see whether the business interruption which they suffered would be covered by insurance, and the answer to the majority of insurers was no. That resulted in the FCA bringing a test case in the High Court, seeking a declaration as to whether a certain number of business interruption wordings and policies in the context of non-damage to property, to see whether those types of clauses were engaged by the pandemic. The case is ongoing at the moment. It's likely that the judgment will be handed down in due course. The other point is that the judgment will be based on the particular sample wording that has been put forward by the FCA and the number of insurers that have agreed to be parties to the proceedings. And so there's unlikely to be an overarching point of principle that can be applied in all cases. However, the breadth of example policy wordings that have been put forward by the FCA hopefully means that greater clarity will be achieved in that area. Now, we don't have time today to delve into the details of the case, but I've put on the slide here a number of issues that are covered, and really to underline that it's not quite as straightforward as one would first imagine. So, for example, one of the key issues is that of causation, and whether the cause of the insured's losses is the relevant insured peril. And that might seem obvious at first blush. You might think, well, there's the pandemic, this has caused me all of this. But again, in each case, it's necessary to look at the particular wording and to see the circumstances in which the clause is covered. So, for example, is it the outbreak of infectious disease? Is it the imposition of government intervention in order to stem the control of the disease? There are also issues such as trends clauses. What would be happening to the business anyway in light of the pandemic? Is it the type of business that is going to struggle in the post-pandemic world that we're going to find ourselves in? And there are a number of issues relating to the but-for test in relation to causation. And so certainly it's going to be of interest. The submissions put forward alone ran into hundreds of pages. And so my final top tip is to keep an eye on the case and to digest any of the points of principles that might arise from it. So thank you very much for listening to my section of the talk. I'm now going to pass you on to James, who's going to talk through his top tips.
Thanks, Chris. Well, I've got my own 5 top tips as well, obviously. I'm going to run through those fairly quickly now. Some of them are massive, which no doubt would be familiar to you already, given where we are in the corona virus situation. But it's always worth reminding ourselves, I think, of some of the key points and seeing if there's been any recent changes which we need to be aware of. Now, the first question is, what are the landlord's remedies for non-payment of rent? Obviously, we had a lot of tenants, a lot of commercial occupiers who either couldn't or elected not to pay rent as soon as lockdown occurred. Many of them did it for very good reasons. They typically didn't have the financial resources to pay rent. The business wasn't generating any income. The cash simply wasn't there. And that has had an obvious impact also on landlords and landlords' finances. In general terms, if a tenant isn't paying rent, a landlord has a fairly limited range of traditional remedies. A landlord might want to forfeit. He might serve a statutory demand as a precursor to winding up. He might go down the route of exercising the commercial rent arrears recovery regime, which replaced distress. He might simply sue for the rent, a traditional debt claim in the county court or the high court, depending on the value. Or if there's a former tenant or a guarantor, he might go after them. Or alternatively, if there's a rent deposit, he might draw on that and then seek to get the tenant to top it up. Most of those options are still available to landlords. You can still sue for debt. You can still pursue former tenants or guarantors if you've got them. You can still call on rent deposits and so on. There have been, of course, 3 major changes. A small change to the commercial rent arrears recovery regime, and 2 major changes to the law on forfeiture and winding up petitions and statutory demands. I'm not going to talk in any detail about the commercial rent arrears recovery regime. The main point there is that the amount of rent that has to be outstanding before you can exercise the remedy has increased to 189 days worth of rent. Before that, it was fairly limited. There was a short period of time when it was extended for a longer period, but now we have 189 days worth of arrears before you can exercise the remedy. In my experience, CRA isn't hugely popular with landlords. It requires a particular procedure to be followed, notices have to be served and so on. You can only seize goods on the premises, and particularly during lockdown, a lot of commercial tenants simply removed goods from their properties anyway. So the attractiveness of it, I think, went downhill from that as well. In terms of statutory demands of winding up petitions, obviously there was a change in the law as a result of the Corporate Governance and Insolvency Act. Chris, if we could move on to the next slide, that would be good. The most relevant provisions under that act was that you can't rely on a statutory demand which has been served between the 1st of March and the 30th of September. And you also can't present a winding up petition between that period based on a company's inability to pay its debts unless you reasonably believe that COVID-19 has not had a financial impact on the debtor. I suspect that test will be very, very hard to satisfy in any event. The Act doesn't say that you can't serve a demand, of course. It simply says that you can't rely on one. And we have had instances of landlords threatening to serve statutory demands on tenants, and indeed in some cases actually serving them. I'm not quite sure why that step was taken in any particular case, unless it's a slight misunderstanding about the actual operation of the Act, because I think it's fairly clear that you simply can't rely on a statutory demand served at the moment, and therefore there's absolutely no value in serving one. What will be interesting, I think, is whether we'll see a raft of statutory demands and winding up petitions being presented when the current period ends on the 30th of September. There is, of course, always a possibility that the period might be extended beyond that. Forfeiture is, again, something which has been changed dramatically. This applies to commercial tenancies only. It has an effect on things like agricultural tenancies, and a separate regime applies to residential tenancies. The commercial tenancies to which it applies is fairly widely construed. The Act refers to 1954 Act tenancies, but I think it's widely agreed that the provisions will apply to all tenancies which might potentially benefit from protection. So even if you don't have protection because you've got an intermediate lease, for instance, and you're not in occupation for the purposes of your business, you might well still be able to rely on the ban on forfeiture for non-payment of rent. That's particularly the case, of course, because if you forfeited an intermediate lease, the subtenant's interest would also be forfeited, and therefore the benefit of the Act would be lost in that case. So I think it's widely accepted that the provisions of the Act apply generally to commercial tenancies in a very broadly understood way. Now, the changes in the legislation as a starting point, as I say, are to prevent the landlord from forfeiting for non-payment of rent during the particular period, and that expires on the 30th of September. There's also been an additional change to the law on forfeiture, which follows from the nature of forfeiture. We often think of forfeiture perhaps as a contractual right, or akin to a contractual right to terminate for the tenant's failure to comply with its obligations under the lease. And that's not quite right. Although a forfeiture right depends on there being a forfeiture clause in the lease, it's really an equitable remedy. And it's a remedy which involves the landlord making a choice. The landlord has to elect to treat the lease as having come to an end. It's not quite the same thing as a break right, for instance. And because it's an election, because it's a decision by the landlord to say the lease has stopped because of the tenant's breach, the landlord can do something which will prevent him relying on that right, because he might do something which is inconsistent with deciding that the lease has come to an end, and that's called waiver. The most traditional example of waiving the right to forfeit is if you demand rent which is due after the last rent was unpaid. And in order to take account of that, what the law does now is say that during the relevant period, so from the period from the 1st of March to the 30th of September, the landlord can't do anything which will waive his right to forfeit for non-payment of rent. So throughout this period, landlords and tenants have been dealing with each other as if the lease has been continuing, even where tenants haven't paid the rent. But none of that, at least on a strict reading of the Act, can have any impact on what happens on the 1st of October. And in theory, it seems to me, a landlord could quite reasonably turn around on the 1st of October and say, well, the March rent wasn't paid, hasn't been paid in the meantime. I might have had some dribs and drabs, but accepting those payments or accepting a payment of part rent in June hasn't waived my right to forfeit for the March rent, and therefore I could go ahead and proceed to forfeit the lease. Now, we don't know whether that's going to happen, and we don't know how the courts would approach that point in practice. It does seem very harsh, and it probably would go towards a tenant's right to claim relief from forfeiture, but it is a theoretical possibility. The other point that has affected the landlord's right to forfeit is, of course, also that there has been a procedural stay on court proceedings generally for possession. Landlords don't have to take court proceedings to forfeit a commercial lease as long as there's no residential element. But apart from that, a lot of landlords do actually prefer to go down the court route rather than actually just simply changing the locks. And because there's been a court stay in place, that hasn't been possible in the current scenario. So you could issue proceedings, but the court simply wouldn't do anything about them. A new practice direction is coming into effect on the 23rd of August, which will allow people to reactivate claims which were stayed during the relevant period, and new claims will be dealt with by the courts. One of the things we'll be looking at shortly is what impact that's going to have on dispute resolution generally, because there's clearly going to be a large backlog of litigation for the courts to deal with. There's going to be a large backlog of possession claims for the courts to deal with, and the whole process is likely to be much slower and even less satisfactory than it is at the moment. Thanks, Chris. So my main tip on that point, I think, is just to recap, is that rent remains payable despite the lockdown rules, the changes in the law, and the best thing to do is really to engage with the landlord if you can't afford to pay the rent, and come to some sort of arrangement if you can. That takes us into the question of rent reductions. And again, this is something we saw a lot of during lockdown and at the start of lockdown, is whether tenants were entitled to seek to have a rent reduction as a result of lockdown and the new rules. As a general rule, you are not entitled to a rent reduction. The rent remains payable, and it remains payable at the full level in the lease, unless there is a rent review that happens at a convenient moment or something along those lines. Of course, one of the things we have seen recently is the government's introduction of the Code of Practice for the commercial property sector, which has introduced guidelines for landlords and tenants to negotiate things like rent reductions, staggered payments of rent which aren't in accordance with the lease, different regimes for service charge payments, and so on. And that's been something which obviously is intended to help tenants and intended to encourage the sector to work together to deal with the problems that have arisen. I think the main thing to remember is that it's not mandatory. It has no real legal force, and it certainly doesn't provide a defence to a debt claim. Certainly I've seen some tenants coming to me saying, well, the landlord's paying no attention to the code, what can I do about it? And apart from making some noises about costs, if the landlord decides to proceed with a debt claim, non-compliance with the code isn't really going to help a tenant particularly. So I think that notwithstanding, it is still fundamentally important to try and engage with the landlord, or indeed if you're a landlord with your tenant, to see if there's some way in which you can agree reasonable terms which are satisfactory to both parties. So again, it's a question about talking to each other and making sure that you understand the other side's position. The tenant who simply ignores his landlord's requests, or indeed the landlord who simply ignores his tenant's requests, is likely not to be viewed particularly favourably by the court. The other option that might be available in some cases is if you do have a tenancy which is protected by the 1954 Act, and you're either getting towards the end of the fixed term or you're already in a continuation tenancy. And in that case, serving a Section 26 notice as a tenant might well be a sensible option, because obviously when you serve the notice, the rent under the new tenancy will be determined as a market rent, and that will take account of the drop in the market at the moment generally. So you may end up with an ability to get a lower rent by engaging the 1954 Act. Of course, the corollary of that is you will end up with a new fixed term lease, which might not give you the same amount of flexibility with the premises that you might otherwise have if you simply let the lease roll on under the Act. As Chris mentioned in that context, we are seeing quite a lot of tenants asking for, in their Section 26 notices, new clauses in the lease to cover pandemic/lockdown situations. So COVID-19 breaks, pandemic breaks, rent suspension clauses, and so on. We don't yet know how the court would approach clauses like that. The general principles are that the terms of the new lease should be the same as the old lease, but and if a party wants to depart from those, it has to justify the change. But the court's essential duty is to do justice between the parties. So we're not quite sure how those clauses will be viewed by a court at this stage, but it's certainly something worth bearing in mind. Thanks, Chris. That also, I think, leads us into the question of early termination. If you can't get a rent reduction, can you get out of your lease if you want to? And again, as Chris has highlighted, in the absence of arguments about frustration or force majeure, there's no right to terminate a lease early unless there's a break clause. I think the key point here is to make sure you've read your lease and know what the break conditions are if you've got one. Break clauses require, with conditions attached, require the conditions to be strictly complied with. A lot of break clauses require the rent to be paid in full. So you have to bear in mind that if you're going to exercise your break and you want the break to be effective, you may well have to pay the whole of the rent in order for that to take place. And the question then is that going to be viable in terms of the cash flow of your business and the wider situation? But I think it's really important to bear that in mind, that a break clause isn't always a simple get out clause because of the potential conditions attached to it. Another little point which is worth bearing in mind, if you are in a continuation tenancy, so your fixed term has expired and you're holding over under the 1954 Act, you can terminate that tenancy on 3 months' notice under Section 27 at any time. So there's a value in holding on to the continuation tenancy because it gives you as a tenant that flexibility to walk away on fairly limited notice when you want to do that. Thanks, Chris. The next question is one about continuing 54 Act protection. I touched on this when we were talking about the non-payment of rent issue. The 1954 Act requires a tenant to be in occupation for the purposes of its business in order for the protection to continue. If you're not in occupation for the purposes of your business when you get to the end of the fixed term of your otherwise 1954 Act protected lease, the lease simply comes to an end. And one of the things that people were obviously worried about with lockdown was whether or not they would be considered to be in occupation. After all, if you can't open your shop and if you've made a decision to move a lot of your stock out, then are you really occupying the premises, and what impact does that have on your continued right to stay in the premises after the fixed term? And I think the answer to this one is that occupation is really a question of control. It's not necessarily presence. There's lots of cases in the context of landlords seeking to take premises back for their own occupation about what the landlord needs to show for the purposes of occupation. And there's lots of cases about tenants who move in one day before their lease expires and says, well, I'm in occupation now, therefore my lease continues. And it really is actually quite a limited test in many ways. So for instance, a tenant who goes into the premises a couple of days before the expiry of the fixed term, puts some desks in, some phones, starts kitting it out, ready to be occupied for commercial use, can still be regarded as being in occupation. So you don't really need to be there running the business, running the property as a full commercial enterprise in order for the protection to apply. So I suspect that, particularly in the current circumstances, most tenants who still retain control of their premises, even if they'd removed quite a lot of the goods for security reasons, would be regarded as being in occupation and so being protected by the Act when the fixed term arises. The other reason this is important is that if you are occupying under a continuation tenancy and you stop using the premises for a business purpose as a tenant, the landlord is actually entitled to terminate because of that cessation of occupation by serving its own notice under Section 24. And if it serves that notice when the premises aren't being used by the tenant for its business, then the tenant can't recover the situation by going back in subsequently. So I think it's important for tenants who are at the moment still not using their premises or are thinking of reducing their premises but want to keep their options open. So for instance, thinking of closing their premises but might want to keep them later on in the next 6 months or so, to make sure that they're simply not clearing everything out, that it's not a gutted shell, but there are things there which show that the tenant is still in control of the premises and using them in some way, even if it's simply keeping the infrastructure in place, desks, phones, and so on. So I think that's the key tip there, is to make sure that if you're a tenant who feels that there might be a risk here and you want to keep the premises, make sure you've got some use for them on an occasional basis. And finally, I think that takes us to dispute resolution. I mentioned before the problems that the courts are likely to experience when it becomes possible to issue possession claims after the 23rd of August. This is for residential and when we get back into the world of winding up petitions and general possession actions after the 30th of September. I think it's fair to say the courts are not, in many ways, an easy forum for people to deal with. They tend to be underfunded, understaffed, and they deal with a vast amount of work. It's a very frustrating process to go through, and it takes an awful lot of time. So the question is whether there are other options which landlords and tenants might think about in order to pursue the resolution of disputes. Again, there are some fairly well-recognised options, things like arbitration, mediation, or expert determination. The key point here is to check the lease terms. A lot of leases include particular dispute resolution clauses, often requiring arbitration or expert determination. But you need to be clear that those clauses cover the particular scope of the dispute. So some dispute resolution clauses in leases will only cover particular types of dispute under the lease. So if you want to engage those sorts of provisions, you need to make sure that what you're actually arguing about is covered by them. In any other case, alternative dispute resolution requires both parties to consent. And it's probably worth thinking about, if only because alternative dispute resolution can, in a lot of cases, be quicker, simpler, and certainly a lot cheaper than going down the court route. So I think that's all I had to say about dispute resolution. That brings my, my 5 top tips to an end. Thank you very much for listening.
Thank you, James. It's just coming up to 10:45 now, which is the end of our allotted time. There are 3 questions that have been sent through, so thank you for those. I was going to propose that James and I spend a few moments discussing them. I appreciate that some of you might have other appointments to get to, so please do feel free to drop off at this point in time. And again, just to remind anybody, if you do have the chance to leave any feedback or suggestions for future topics in the Q&A, please do so. So I see there's been a question about structural alterations which require landlord's consent, and the question is, what if you have made structural alterations due to COVID-19 health and safety requirements? So in that regard, the first step is to check the terms of the lease and to see what the lease says about what type of alterations a tenant might make, and where landlord's consent is needed, whether that consent must not be unreasonably withheld or delayed. In the circumstance where there is an absolute prohibition on a tenant carrying out structural alterations, but those alterations have taken place, the starting point is that the terms of the lease will still apply, but there is likely, or at least there is a possibility, that there will be a conflict between the terms, a battle of the terms in one sense, whereby a tenant might be obliged to comply with statutory guidance or statutory requirements, which the tenant will say means that it has to carry out these works, but equally there will be the prohibition on alterations in the hypothetical lease that I'm mentioning. In that regard, what you might find is, although the landlord will have the remedies available to it that James spoke about, albeit subject to the current restrictions that are in place at the moment, the temporary restrictions, and in the context of certain long leases with more than 3 years left to run, a further set of restrictions under the Leasehold Repairs Act 1938. Nonetheless, tenants need to be aware that the landlord might have certain remedies available to it. One example perhaps is if the landlord sought to forfeit the lease following a breach of covenant relating to alterations. Once the current moratorium has been lifted and were the matter to go through to court, the tenant might seek relief from forfeiture on the ground that it's complying with statutory regulations, and indeed the tenant might also argue that the landlord was breaching its covenant of quiet enjoyment by rigidly sticking to a proviso which prohibits alterations in the context of COVID-19. And indeed, one would expect the courts to be fairly sympathetic towards tenants in that scenario. Having said that, were a tenant to carry out alterations without the landlord's consent or approval, you'll be on a sticky wicket from the beginning, really. You'll be having to put forward counter arguments, and so it's very much suggested that landlord's prior approval is obtained before carrying out any alterations, particularly structural alterations, because clearly from a landlord's point of view, they're of high importance in terms of preserving the value of the landlord's asset and its reversionary interest. And so care very much needs to be taken. And I certainly wouldn't suggest any tenants carrying out structural alterations without landlord's prior approval in the event that the lease contains restrictions in that regard. One other query that I had in relation to alterations carried out, and the query is whether, if there is a clause in the lease which requires a tenant to return the premises in the state and condition that they were at the beginning of the tenancy, and changes are made in order to make them COVID-19 secure, whether the landlord and the tenant can agree to change this so that there is no liability at the end due to any changes that have been made. So the short answer to that is yes, you can. The terms of the lease can be varied, or otherwise the landlord can agree to waive reliance on a particular argument arising following what would otherwise be a technical breach of the clause. And the key there is to have everything clearly set out and in writing, because of course there's one risk that the parties might have the best of intentions now, and an agreement might be made on a handshake, but in X number of months or X number of years' time, when the lease comes to an end, it's very important that any agreements or variations made are properly documented, including by deed where necessary, just to ensure that there's no uncertainty or confusion at the end. And there's also the point that I mentioned in the talk. There's a small possibility of seeking compensation for tenants' improvements if the changes made represent a lasting improvement to the property. That does require a formal, it's formal in a sense, but at least it requires a procedure to be followed. And so if that is something that tenants are considering, I certainly recommend taking legal advice in that regard. And now I see that there's one final query for you, James, concerning what we're seeing regarding non-payment of rent and what action landlords are taking. And so I'll pass that over to you.
Yeah, I think, I mean, in a sense, it's very landlord dependent. My experience is that most landlords are pretty reasonable, to be honest. When I've seen landlords take additional steps, so I have seen landlords simply suing for unpaid rent, it normally follows a pattern of tenants refusing to engage with the landlord. So it's often seen, I think, by landlords at the moment as a last option, because they don't feel they've got any other option to pursue. Most landlords, in my experience, are looking to agree rent reductions or temporary waivers of rent, but they want to be satisfied that the tenant's simply not paying the rent because it doesn't want to. Some tenants who were frankly very cash rich nevertheless decided at lockdown that we're not going to pay the rent. And I think that got quite a lot of landlords quite angry for understandable reasons, because it's not just tenants who are suffering, it's landlords as well. So where landlords have taken additional steps, such as by suing or issuing proceedings, for a debt claim, it's normally, in my experience, because the tenants haven't actually tried to come to some sort of other arrangement with the landlord, and the landlord simply rather run out of patience at the end of the day.
Thanks, James. Yes, I agree. Certainly, that's what I've been seeing in my experience. Okay, well, thank you, everybody. I hope you found today useful. If you do have any follow-up questions or queries, please do feel free to get in touch with either James or myself, and we'd be more than happy to have a 5-10 minute chat with you just to talk through the issues and to explore them in more detail. Aside from that, thank you once again for joining us today, and we hope to see you soon. Thank you.